Imagine sending your child to school, expecting lessons about reading and math, and instead, they're handed a story about a same-sex wedding or a puppy marching in a pride parade. Now imagine you have no right to say no. That's the heart of Mahmoud v. Taylor, the Supreme Court case that could redefine religious freedom in America's classrooms. Today, we'll unpack every twist, every argument, and every potential ripple effect of a decision that may shape education for a generation. When Montgomery County Public Schools in Maryland first introduced LGBTQ-themed storybooks into their language arts curriculum, they aimed to reflect the real diversity of families in 21st century America. Books like Uncle Bobby's Wedding and Prince and Knight were added as optional materials meant to foster empathy and respect, not coerce belief. Yet by March 2023, the district quietly scrapped its opt-out policy, citing administrative chaos and concerns over stigmatizing LGBTQ students. Suddenly, parents who once could excuse their children found themselves powerless to block lessons that clashed with their deepest religious convictions. Here's the curriculum breakdown. One LGBTQ-themed book per grade from pre-K through 5th grade. Titles included Pride Puppy, My Rainbow, Love, Violet, and more. Initially, parents were notified in advance and could remove their kids from those readings. But as opt-outs surged, some driven by secular objections, others by religious belief, the district decided it was too disruptive. No more opt-outs for any reason. What began as a gentle invitation to inclusivity became a mandate, and that shift ignited the legal spark for Mahmoud v. Taylor. Enter 6 plaintiffs, Muslim, Catholic, and Orthodox Christian families represented by the Becket Fund for Religious Liberty. They sued, claiming Montgomery County's refusal to allow opt-outs violated the First Amendment's free exercise clause. They weren't demanding the books be removed from schools entirely. They just wanted the right to guide when and how their children were exposed to lessons on gender and sexuality. In their view, compelling their 7- and 8-year-olds to sit through these story times forced them to choose between faith and education. The school board's defense was straightforward. These books are part of language arts, not sex education. They're optional supplemental materials, not required textbooks. Allowing opt-outs had become unmanageable. Students were absent en masse on storybook days, and classrooms fractured into in- and out groups. Worse, pulling some kids out risked stigmatizing LGBTQ students, isolating them when they needed support. To MCPS, uniform participation reinforced respect for all families without targeting anyone's beliefs. A federal district court denied the parents' request for an injunction, ruling that mere exposure to ideas, even those conflicting with religious teachings, does not constitute coercion under existing precedents. The Fourth Circuit agreed, emphasizing that simply hearing about other views does not necessarily exert pressure to believe or act differently than one's religious faith requires. In other words, the court said your kid hears the story, goes home, and you talk about it. No constitutional violation. But the parents weren't satisfied. In January 2025, the Supreme Court granted certiorari, agreeing to decide whether public schools burden parents' religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out. The stakes couldn't be higher. A win for the parents could open the door to religious opt-outs for any classroom content evolution, civil rights, even history lessons featuring religious or LGBTQ figures. On April 22, 2025, the justices heard oral arguments in Mahmoud v. Taylor. The courtroom divide was stark. Conservative justices led by Samuel Alito and Amy Coney Barrett pressed the school's attorney on why parents shouldn't retain the fundamental right to rear their children according to their beliefs. Barrett suggested that forbidding opt-outs treated religious objections as second-class, a departure from the court's recent expansion of religious liberties in cases like Masterpiece Cake Shop and Kennedy v. Bremerton School District. On the other side, liberal justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson warned that granting broad opt-out rights could undermine public education. Sotomayor reminded counsel that mere exposure to disliked ideas has never been deemed coercion and asked whether parents could then opt out of math lessons on the basis that it conflicts with a numerology-based faith. Kagan raised concerns about administrative chaos. If parents could pull kids from one lesson, where would it end? Could they then refuse history units on Martin Luther King Jr. or science modules on Darwin? Behind the legal jousting lies a profound question. Who holds the power over a child's moral and intellectual formation, the parent or the state? The plaintiffs lean on Wisconsin v. Yoder, 1972, where Amish families won the right to exempt their children from schooling past 8th grade. They argue opting out of a single lesson is far less drastic than Yoder's wholesale exemption and just as protected under the Free Exercise Clause. The school board counters with Ling v. Northwest Indian Cemetery Protective Asin, 1988, which held that government action short of coercion, even if offensive to religious beliefs, does not violate the Constitution. Legal experts are split on how the court will rule. A narrow decision might simply require Montgomery County to restore its original opt-out procedure, limiting relief to this single district. A broader ruling, however, could mandate that all public schools nationwide offer religious opt-outs for any curricular content parents find objectionable. That could usher in waves of new litigation, from biology and sex ed to literature and history, potentially paralyzing classroom instruction under the weight of opt-out requests. On the courthouse steps, both sides rallied. Parents waving signs reading "My Child, My Choice" argued this is about protecting family autonomy. LGBTQ advocates warned that legitimizing opt-outs institutionalizes stigma, isolating vulnerable students and undermining inclusive education. National organizations from the ACLU to the Beckett Fund have filed amicus briefs, underscoring the case's broad implications for civil rights and religious liberty alike. As the court deliberates, one thing is clear: Mahmoud versus Taylor isn't just about storybooks. It's about the balance of power between parents, schools, and the state. It's about whether public education can maintain a standard curriculum in a religiously pluralistic society, or whether every lesson becomes negotiable based on faith. And it's about the message we send to children, that some stories are optional but others are non-negotiable. The Supreme Court's decision, expected by late June 2025, will resonate far beyond Maryland. Will it affirm parental control over every classroom moment? Or will it uphold the principle that public schools must teach all students even when parents disagree? But before we continue, we can tell you enjoy this type of content, so don't forget to subscribe to the channel and give this video a like. Make sure to turn on notifications too, so you never miss a new video. Would you opt your child out of a lesson that clashes with your beliefs? And check out our next video where we analyze how this decision could reshape debates over evolution, climate change, and more. Until then, stay informed and keep questioning who writes the story in our schools.